Good morning. Everyone, today is Thursday, July 17th, 2025, and the time is 9:02. Thank you all for attending the Police Officer Standard Accountability Advisory Board hearing. Please note that this hearing is being live streamed, recorded, transcribed. Further, please note that the microphones are auto on off. When you begin speaking, they will go live with this. You will need to watch your crosstalk. We will now call the roll for board members. Chandler?
Thank you, Madam Chair. Good morning, members of the board. Member Clavo,
Here.
Member Crawford,
Here.
Member Doyle, Chair Dudley,
Here.
Mr. Glazer. Here. Johnson. Lara.
Present.
And Pena.
Here.
Madam Chair, 6 members present.
Okay, a quorum has been established. I would like to introduce Board Counsel to my left, Christopher Beatty, and Board Assistant Executive Director, Anne Marie Delney-Nejo. This is now the time set aside for members of the public who wish to comment on items not on the agenda, but those within the board's jurisdiction. Public comment on matters on the agenda will be heard after each item is presented. Public comment on specific peace officer revocation cases to be heard today will be heard at the time of the hearing of each such matter. Please be advised that the board cannot take action on items not on the agenda and may discuss those matters only to the extent necessary to determine whether any matter should be made an agenda item at a future meeting, to respond briefly to statements or questions posed, to request clarification, or to refer the items to staff. Please remember that this meeting is being transcribed, so I may politely interrupt and ask you to repeat or speak slowly and clearly so your comment can be correctly captured in the transcript. As the board chair, I may ask members of the public to limit their remarks to no more than 3 minutes pursuant to existing board policy. I may conclude the public comment period if multiple speakers are voicing repetitive or similar statements and the 15-minute public comment period has expired. You will be given 3 minutes to speak and the time limits will be strictly enforced. So please ensure that you complete your comments within the allotted time. Before I open public comment on matters not on the agenda, please note if you wish to comment on disciplinary matters scheduled to be heard today by the board, you must wait until that matter is called to offer public comment. If you have a specific complaint about an officer that is not on today's agenda, you should file a complaint with Post or with the officer's employing agency. Staff will assist you in this regard. I would like to remind individuals making comments to not discuss pending complaints or pending disciplinary actions that may later come before this board for a recommendation if the board takes action on your complaint. You will have an opportunity to address the board at that time. Following these rules is necessary to comply with the law and to avoid compromising the board's mission. So now, is there anyone present in the audience or appearing remotely who would like to address the board during public comment? Let's start with anyone present in the audience first. Is there anyone present who would like to address the board? Seeing none, let me check if there's anyone remotely. And there is not. Okay. So we now move on to the next items on the agenda. We have 2 cases to hear today. We will only be reviewing the facts and evidence as presented by this division. This is not an evidentiary hearing. The rules of evidence do not apply here. Evidence is not formally admitted into the record. There is no need to make any objections, and objections will not be ruled upon. Under the Penal Code and applicable state regulations, this initial hearing will determine only if the matter will proceed forward to the commission review. And then, should the commission approve for a full evidentiary hearing before an administrative law judge to determine whether the allegations are true and justify discipline. For those commenting on each item at this early stage, the board must only consider the facts that the division, after investigation, believes can be proven at a later evidentiary hearing. For that reason, today the board will entertain arguments as to whether or not those facts as presented by the division demonstrate clear and convincing evidence. In other words, a high probability that serious misconduct as defined in Penal Code Section 13510.8 and Commission Regulation 1205 occurred. This finding results in the matter being moved forward. No action by the board or the commission prior to a full evidentiary hearing amount to a final determination that an officer did in fact engage in misconduct or that revocation or suspension is ordered. That will be determined after the evidentiary hearing. At the conclusion of each law enforcement consultant's presentation, the board will have the opportunity to ask questions. Then public comment from the subject officer and/or their counsel will be taken, followed by the members of the public. Further discussion by the board will be allowed if necessary. The board may then go into closed session deliberations after each case or wait until the end of all cases have been presented and adjourn to closed session to deliberate on all cases presented. After reconvening into regular session, votes will be taken on each case. We're now going to move on to post case number 2316745, Jared Britton. Post C63-Z34. At this time, I will now call upon law enforcement consultant Paul Nenefito, Professional Conduct Southern Bureau, and Kerry Woolley, Attorney for Legal Affairs Bureau, to provide a report on case post 2316745, Jared Britton, who at the time of the events at issue in this case was employed with the Orange County Sheriff's Department.
Madam Chair, I just wanted to recognize,
Please.
I believe that Board Member Johnson was missed on the roll call and is present. So
Okay,
for the
thank
record.
you.
Yeah.
Correct, Board Member Johnson?
Yes.
There you are. Present.
I don't know whether I missed it or, but yeah. Good morning.
Thank you,
Morning.
Council. And we're now ready for the presentation.
Thank you. Good morning, Madam Chair and members of the board. My name is Paul Nanfito, and I am one of the law enforcement consultants assigned to the Professional Conduct Southern Bureau in the Peace Officer Standards Accountability Division. With me today is Kerry Woolley, an attorney with our Legal Affairs Bureau. I am here today to present case number post 2316745. It involves Deputy Jared Nathaniel Brittain from the Orange County Sheriff's Department. Hereinafter, he will be referred to as the respondent. It is the division's determination that clear and convincing evidence exists to demonstrate the respondent committed multiple acts of serious misconduct as set forth in Penal Code Section 13510.8 on multiple dates between June 1st, 2022 and October 5th, 2023. Specifically, the division has determined that the respondent committed the following acts of serious misconduct: dishonesty, 13510.8 paren B paren 1, providing false statements and information to internal affairs investigators during 4 separate internal affairs investigations. Acts that violate the law, 13510.8 paren B paren 6, acts that are sufficiently egregious or repeated to be inconsistent with a peace officer's obligation to uphold the law or respect the rights of the members of the public as determined by the commission. In this presentation, I will present a brief outline of the division's findings of the investigation in this matter. The respondent began his career with the Orange County Sheriff's Department on March 31st, 2017 as a trainee, and on November 8th, 2017, he was promoted to the position of Deputy Sheriff. The respondent holds the following post certification: basic, intermediate, and advanced post certificates. The respondent has no prior disciplinary issues to discuss. The respondent was awarded the Orange County Sheriff's Department's Medal of Valor for his response to a critical incident that occurred on August 23rd, 2023. This was an incident involving an active shooter who shot multiple people and engaged responding deputies in a 7-minute gun battle. The respondent was recognized for making the courageous decision to form a team, climb a hill behind the suspect from a flank position. This is a verbal presentation, which I am providing from a prepared statement, which will be followed by a PowerPoint presentation. The PowerPoint will provide a visual representation of the timeline of events and some of the specific statements which you will hear during the verbal presentation. In summary, this case will cover 2 different internal affairs investigations, which included 4 interviews. These events took place over a 17-month period from June 1st, 2022 through October 5th, 2023. On June 1st, 2022, the respondent was off duty and was stopped by the California Highway Patrol. Prior to the traffic stop, the CHP officer made the following observations. The driver of a black Ram 1500 pickup truck driven by the respondent was bumper paced at approximately 104 miles per hour. He was also weaving dramatically from left to right within the traffic lane, crossing over the lines on both sides of the lane. The CHP officers initiated a traffic stop and contacted the driver, who was identified as the respondent. He identified himself as an off-duty peace officer and that he had multiple weapons in his vehicle. The respondent had a firearm in his waist and had SWAT weapons inside the pickup. On October 7th, 2022, the respondent pled guilty to 2 misdemeanor counts of driving under the influence of alcohol and admitted to having a blood alcohol content of greater than 0.20 in the Orange County Superior Court. As a result of this conviction, the Department of Motor Vehicles suspended the respondent's driver's license. The DMV mailed the respondent a notice of this suspension, which was dated October 14th, 2022. This suspension was effective from October 7th, 2022 through April 7th, 2023. The notice was sent to the respondent's home address. Notifying him of the suspension was effective on October 28th, 2022. The respondent was in court when he was advised by the court of a Superior Court document, which is referred to as a declaration regarding Vehicle Code Section 313550, which notified the respondent his driver's license was confiscated at the time of his arrest and it had not been lawfully reissued. It was signed by his attorney and was dated October 7th, 2022, and the respondent was present when this occurred. The respondent did not notify his chain of command at the Stanton substation of his driver's license suspension. He continued to work his regularly assigned patrol shifts at this station. During the week of December 20th, 2022, the respondent went to his mailbox and retrieved a notification from DMV, which was dated October 14th, 2022. The document was the DMV order of suspension, which reads in part, "Your privilege to operate a motor vehicle has been suspended effective October 7th, 2022, and shall not be reinstated before April 7th, 2023. The respondent acknowledged that it was this document which was the catalyst for him to respond to the DMV on December 20th and obtain the restrictions on his license which would allow him to legally drive a motor vehicle. On December 20th, the respondent went to the DMV office where he received and signed a DMV verbal notice of actions. This document lists 2 separate license suspensions. One was effective 10/7/2022 and one was effective 10/28/22. By signing this document, the respondent was notified about both suspensions and the length of those suspensions. This date and these notifications are critically important because the respondent attended his first internal affairs interview the following day on December 21st, 2022. This interview was the first inquiry into his DUI arrest by the Orange County Sheriff's Department internal affairs investigators. Now I will provide you with some examples of statements made by the respondent which have been determined to be dishonest. During this interview, the IA investigator asked the respondent if his license was fully suspended at any time. In response, he said, for a period of, I believe, 30 days from the sentencing until I could get it restricted. It is important to note that just the day before making this statement about a 30-day suspension, the respondent just received those restrictions on his license, allowing him to drive legally. This document, which brought him to the DMV that day, stated his license had been suspended effective October 7th, 2022, and could not be fully reinstated until April 7th, 2023. On the day he signed the DMV verbal notice of actions, which notified him that his driver's license was fully suspended on October 7th, 2022, until December 20th, 2022. This is clearly not a 30-day suspension, and there is not a document which mentions a 30-day suspension. The IA investigator asked the respondent the following specific and direct question. He asked, "How did you get to work?" The respondent said, "I had a friend drive me that I work with, and I had a trainee in the car I was working with." The IA investigator specifically asked the respondent, "So you had the trainee driving the whole time while you were doing your patrol work?" The respondent said, "Yes, sir." A review of traffic cameras within the city of Stanton, California showed the respondent driving a black Ram 1500 on 10 specific dates between October 7th, 2022 and November 7th, 2022. The respondent's driver's license was fully suspended during this time frame. Surveillance cameras at the Orange County Sheriff's Substation in Stanton, California showed the respondent driving a black Ram 1500 pickup into the parking structure across the street from the substation. The respondent attended a follow-up administrative interview regarding the DUI arrest on February 15th, 2023. This was another opportunity where the respondent could have been forthright and advised the investigator that he had been driving during the period of his suspension. Instead, he provided deceptive and dishonest statements. He also provided another affirmative answer to a question about his trainee driving him while at work, and that he only received a 30-day suspended driver's license. Following excerpt from this interview illustrates the continuing deception of the respondent. The IA investigator asked the respondent, "You had a 30-day suspended license," to which he said, "Yes, sir." The IA investigator then specified, "And that was at the time of the conviction, so October 7th to November 7th? Respondent answered, "From what I recall, sir." As previously noted, the respondent received DMV paperwork on December 20th, 2022, which clearly stated the length of his suspensions. These statements are simply not true. The IA investigators focused on the time period between October 7th, 2022 and November 7th, 2022. They did not focus their inquiry and evidence collection from November 8th, 2022 through December 20th, 2022, because the respondent kept telling him his license was only suspended for 30 days from October 7th through November 7th. Respondent's deception resulted in the loss of traffic camera videos and photos, as well as Stanton substation surveillance photos during the division's inquiry. The IA investigator asked a clarifying question. "And I think you mentioned in the video you were getting a ride to and from work and you have a trainee." The respondent said, "Yes, sir." On December 28th, 2022, 7 days after his first IA interview, officers from the Anaheim Police Department responded to a call from a citizen who reported finding a firearm in a black Ram 1500 pickup she had rented from a local car dealership on December 14th, 2022. The reporting party told the officer she was cleaning and checking the rental vehicle at her home with the intention of returning the vehicle to the dealership on December 29th, 2022. The reporting party told the officer, while checking the vehicle, she lifted the front seat center armrest and discovered a firearm. The reporting party told the officer she had not noticed the firearm until she lifted the armrest, and she immediately called the Anaheim Police Department. With that, the officer secured the firearm, a Glock 19, which was later determined to have a full magazine of 15 rounds with 1 round in the chamber. The Anaheim police officers ran the serial number on the firearm and determined that it belonged to the respondent and it had not been reported missing or stolen. Anaheim police officers contacted the respondent on December 28th about the firearm and asked him if it was in his possession. The respondent replied, "That's a good question." Respondent then told the officers he had not seen the firearm in a month or two and did not report it as missing or stolen because he had not noticed it was missing. On January 3rd, 2023, the Orange County Sheriff's Department initiated a second internal affairs investigation regarding the respondent's personal Glock firearm that was located inside a rental truck on December 28th. It should be noted that the respondent returned the Ram 1500 rental truck on December 13th, 2022. The next day, it was rented to another citizen in the city of Anaheim. This citizen drove this vehicle unaware there was a loaded firearm beneath the center armrest for 2 weeks. Respondent violated Penal Code Section 25140(b) when he left his handgun unsecured in the rental vehicle. Under Penal Code Section 25452, a peace officer shall, when leaving a handgun in an unattended vehicle, secure the handgun in the vehicle pursuant to Penal Code Section 25140. The respondent attended his first IA interview regarding the unsecured handgun on August 9th, 2023. This would be his third IA interview since December 21st, 2022. During this interview, the IA investigator asked follow-up questions about the respondent's truthfulness during his first two administrative interviews. The IA investigator had located traffic camera video and pictures that showed the respondent driving a black Ram 1500 pickup in the city of Stanton and into the parking structure across from the Orange County Sheriff's Department Stanton substation. He also located surveillance photographs of the respondent walking into the Stanton substation. This IA investigator was aware of the previous IA regarding the DUI arrest. These photographs are what led him to ask the respondent some follow-up questions about the respondent's truthfulness during the first two IA interviews. The respondent's answers to some of these questions continued to be deceptive and dishonest. During this interview, the IA investigator stated to the respondent, "I have you on camera driving to work." The respondent said, "Yes, sir." The IA investigator added, "And your rented truck during those days?" Again, the respondent said, "Yes, sir." The IA investigator then asked the respondent very directly, "So when you say you were being driven to work, is that the truth, or were you driving yourself to work?" The respondent said, "I drove myself to work, sir." The IA investigator assigned to investigate the unsecured firearm scheduled a second interview with the respondent on October 5th, 2023. This would be the respondent's fourth interview over the course of approximately 10 months. The critical incident that was previously mentioned occurred on August 23rd, 2023, which is after his third interview, but before his fourth IA interview. There were several statements the respondent made during his final interview which were determined to be dishonest. Leading up to this interview, the IA investigator obtained body-worn camera footage showing the respondent driving a patrol car between October 7th, 2022 and November 7th, 2022. His license was suspended during this time frame. The IA investigator asked the respondent if he remembered stating during the interviews with the first IA investigator and later with him that your trainee drove your patrol car while you were at work. The respondent said, "Yes, sir." The IA investigator then asked, "Is there anything about that statement you would like to change?" The respondent replied, "After you guys advised me of the dates in question, there may have been a day that I have driven, whether it was to move the vehicle or I may have driven on my own. I don't recall specifically what day that was." During the respondent's fourth and final interview, he offered an explanation as to why he didn't answer completely about driving during his suspension period. Specifically, the respondent said, "I obviously drove during work and I couldn't recall specifically when or if I did, and then thinking back into it, ultimately I was confused on the dates. There's multiple suspension dates that I was given and the reason I gave the answer that I did." The evidence shows that any confusion about suspension dates on the part of the respondent was cleared up when the respondent went to DMV on December 20th, 2022, where he received his verbal notice of actions with the actual suspension dates, as well as receiving the order of suspension earlier that week. At the respondent's request, he was interviewed by the division on October 23rd, 2024. During this interview, he again made the assertion that he was confused about the dates of his suspension and said the suspension may have been in effect later in November of 2022. The respondent stated he would provide copies of DMV paperwork to show the different suspension dates that created his confusion. The division later received an email from the respondent's attorney stating he could not locate the DMV paperwork he referenced during this interview. However, the respondent's attorney did provide the division with a letter from retired Orange County Sheriff's Department Assistant Sheriff Stephen Kia, which was presented at the respondent's Skelly hearing. A copy of that letter is included as attachment O to the ISF. In the letter, retired Assistant Sheriff Kia addressed several specific points of the respondent's interviews and argued that the respondent was not untruthful because he responded to the questions he was asked, which did not directly ask him whether he ever drove to work or ever drove on patrol. Not only does this representation of the respondent's answers misrepresent the evidence, but retired Assistant Sheriff Kia's summary does not address the respondent's affirmative statement to investigators that his driver's license was suspended for 30 days from the date of his conviction. Further, from the contents of this letter, it appears that retired Assistant Sheriff Kia was unaware the respondent visited the DMV on December 20th, 2022, the day before his first IA interview, where he obtained a restricted license which allowed him to drive legally to and from and in the course of employment. The document received on this date clearly would have shown retired Assistant Sheriff Kia the dishonesty in the statements the respondent made on December 21st, 2022, and during subsequent interviews. For these reasons, the division did not find retired Assistant Sheriff Kia's letter persuasive. Following this interview, the division received DMV documents from the Orange County Sheriff's Department Internal Affairs Division. Specifically, the division received a copy of the order of suspension dated October 14th, 2022, and the verbal notice of actions dated December 20th, 2022. Based on the dates of the suspensions listed on these documents, the division requested additional documentation. The division obtained body-worn camera footage, respondents' patrol schedules, respondents' timesheets, field training officer trainee assignment schedules, and daily observation reports for 2 trainees. All the requested documents were for a time period from October 7th, 2022 through December 20th, 2022. The preceding information was reviewed, which revealed the respondent drove a patrol car on many additional dates during the times he was assigned a trainee. This information revealed that a trainee was not available frequently enough to be able to drive the respondent the whole time he was working his patrol shifts. Based on this new information, the division requested that the respondent participate in a second interview. This interview took place on January 14th, 2025. During this interview, the division reviewed with the respondent the order of suspension and the verbal notice of actions. The respondent was asked specifically how long his driver's license was suspended before obtaining the restrictions on his driver's license. The respondent said, "Knowing what I know now, it was from 10/7 to 12/20, sir." The division then asked the respondent, "So that wasn't explained to you when you obtained this document, or you didn't deduce that from receiving this document on December 20th? In response, he said, "No, sir. Like I stated in the interviews, I was confused on the entire process. I had not received a DUI or dealt with a license suspension before, and my experience with it in the field was limited as well." The documents that the division reviewed with the respondent were copies of the exact same documents he received on December 20th, 2022. Based on this, it is highly probable that he had the exact same knowledge about his suspensions on December 20th, 2022, and on December 21st, 2022, during his first IA interview. The respondent was also asked about who had provided him with rides to and from work. He specifically mentioned Deputy Monero, a coworker from the Stanton substation, who had provided him rides to work. Based on this information, the division scheduled an interview with Deputy Monero on March 4th, 2025. During this interview, Deputy Monero was asked if he had provided rides to work for the respondent during the time period his license was suspended. His answers were initially vague, but eventually he described some ride sharing the two would do for SWAT training. At the end of the interview, Deputy Monero's attorney asked a clarifying question about whether Deputy Monero gave the respondent rides to the Stanton substation, and I quote, "during the time you guys worked there together." Deputy Monero responded, "Not that I can remember." The division obtained the patrol schedule and timesheets for Deputy Monero. The information showed that Deputy Monero's schedule was considerably different than the respondent's, making it very improbable that he was even in a position to provide transportation for the respondent during the time frame his license was suspended. The facts that I've just recited support the division's finding that Jared Nathaniel Pertain was involved in serious misconduct, specifically dishonesty and repeated and/or egregious acts that violate the law. The facts of this case clearly established that the respondent was untruthful during 4 administrative interviews, had multiple opportunities to provide complete and truthful answers, but he chose not to. The acts that violate the law included DUI, drawing on a suspended license on multiple dates, and leaving an unsecured firearm in a vehicle. For purposes of the division's analysis, clear and convincing evidence means evidence of a charge is clear and convincing so long as there is a high probability that the charge is true. The evidence need not establish a fact beyond a reasonable doubt. The division recommends that Jared Nathaniel Pertain's post-certification be revoked. I will now present the PowerPoint presentation to provide a visual timeline of the events and information provided during this presentation. Next slide. So this slide represents the beginning of the triggering events for this whole investigation, June 1st, 2022. I just want to highlight 2 things about that DUI arrest. He was stopped for doing 104 miles an hour, and he had a BAC of 0.20, which is extremely more than twice the legal limit. October 7th is when he pled guilty to the 2 misdemeanor DUI counts and admitted to having a 0.20 BAC. October 14th is a date that I mentioned several times. This is when DMV sent the order of suspension. This is an important document that comes up later on the week of December 20th. Next slide. This is the actual screenshot of the order of suspension, and it's not very clear on the screen there, but I want to read that first line above the little spreadsheet there. It is where it says, it's the very first sentence on this document. It says, "Your privilege to operate a motor vehicle is suspended effective October 7th, 2022, and shall not be reinstated before April 7th, 2023. This is a very simple document, one-page document, easy to read, easy to understand. Next slide, please. Okay, this is the December 20th. This is the day before the first IA interview. It was this week that he obtained the previous document, the order of suspension. And then on this date, he went into DMV, and this is the document that he signed. It is the verbal notice of actions. This is the document that lists 2 specific suspensions. As you can see there, one is effective 10/7/22 through December 20th. The other is 10/28/22 through December 20th. The respondent acknowledged in his division interview that he did sign for this document. This is actually a written document that notices the person that they were verbally notified of these suspensions by DMV. Next slide, please. Again, he attended his first interview on December 21st, the very next day. Next slide, please. As we pointed out in the presentation, the respondent was asked specifically if he, if his license was fully suspended at any time. And his responses do not reflect what he just learned on December 20th. The period that he was suspended is actually 74 days, not 30 days. Next slide. Again, in the same interview, he's asked questions, and the BWC footage that was collected at 2 different points in this investigation. The first 5 were collected by the IA investigators. The rest were collected when I requested them during the investigation. He drove 18 times in a patrol car, and I just want to point out that during the investigation, we requested just 1 sample of driving during those. We didn't request every BWC footage available on each of those dates. Next slide, please. Again, he says, so you had the trainee driving the whole time while you were doing your patrol work. This simply isn't possible. There, on page 22 of the ISF, you'll find a simple spreadsheet that lists all 18 of those dates. There are 7 times that he had a training in the car where he still drove the patrol car. Next slide, please. December 28th is the day that the firearm was located in the rental truck. And as discussed, the investigation was authorized on January 3rd. And on February 15th, he had a second interview regarding the DUI arrest. Next slide, please. Again, he continued to say that he had a 30-day suspended license. It's simply not true. The information he obtained on December 20th clearly showed him the length of his suspensions. Again, I want to point out that the suspended license was effective for 74 days before restrictions. Next slide. August 9th, he has his first interview regarding the unsecured firearm. And this is where the investigator began questioning about his truthfulness in the first 2 administrative investigations. Next slide. Respondent again gives a statement that some days his father and then Deputy Monero, who's the person driving him to and from work. As I noted in my interview with the Deputy Monero, he did not recall doing that. Next slide, please. October 5th, 2023, this is the final interview and the second one regarding the unsecured firearm. Next slide. And the BWC footage contradicts his statements. Next slide. On December 14th, 2023, the Orange County Sheriff's Department served the respondent a notice of intent to terminate. He had a Skelly hearing, and following that Skelly hearing, he was provided the last chance agreement, which resulted in his demotion and reassigned to the jail. Next slide. The respondent division mailed a letter of investigation on September 12th. At his request, he was interviewed on October 23rd, and then again on January 14th, 2025. Next slide. Again, he was asked about who was driving the patrol car, and he said, when I had a trainee in the vehicle, yes. BWC footage contradicts that, shows him driving while he did have a trainee. Also, the trains were not available to drive him in all the dates that he worked during that time frame. Next slide. So under Vehicle Code Section 14601.2A, a person shall not drive a motor vehicle at any time when that person's driving privilege is suspended or revoked for a conviction of violation of 23-152, if the person so driving has knowledge of the suspension or revocation. It also states that knowledge of the suspension or revocation of the driving privilege is conclusively presumed if mailed notice by the DMV pursuant to Vehicle Code Section 13106. As previously noted, and the documents show that he was mailed that notice on October 14th, 2022. Next slide. This was mentioned in the presentation regarding the unsecured firearm. The important thing that I want to point out about this is not a case of an officer leaving a firearm in his truck parked out in front of his driveway. This is a case where a citizen was driving a vehicle for 2 weeks with a loaded firearm unbeknownst to that person. Next slide. That I'm happy to answer any questions that you may have.
Okay, from the board, are there any questions? Yes. Dr. Klava, did you have a question?
Yes, ma'am. The Dodge Ram, was a police vehicle?
No, it was not. It was a rented vehicle from a dealership.
Okay. And then it was a Glock that was left in the car, 15 rounds and one in the chamber?
Correct.
And who notified the department, the DMV? Or did Mr. Brittain notify them eventually?
Of the suspensions,
Yes.
the reports reflect that the respondent did not notify his Stanton substation that he had a suspended driver's license. I'm not sure at what point the department received the DMV documents that I showed you. Those were obtained during the internal affairs process. The department, I can't explain why they were unaware of the suspension. The typical process would be DMV would notify them, but they apparently weren't notified.
And then it was 10 days that you guys pretty much pulled, that was on camera showing him driving? Was it, did I write that right?
The traffic
he drove-
camera systems in Stanton, California were obtained by the IA investigators for a period of October 7th to November 7th. And those were the dates that are identified. The dates from November 8th to December 20th, because the division made that request in 2024, had already been purged, so they were unavailable.
One last question. Did I hear or understand right that the sheriff wrote a supporting letter on the assistant sheriff wrote a supporting letter on behalf of Mr. Brittain, but not having all the facts?
That was a retired assistant chair.
Okay.
But I didn't answer your question. I just wanted to clarify that that
It
was
a
someone who had
retired assistant
retired.
sheriff.
That was a retired assistant sheriff. He wrote that letter for the Skelly hearing. In that letter, and nor in the IA investigations, is there any mention of the documents that the respondent received on December 20th and the week of December 20th. So I do not know why or if he had that knowledge, but it was not in the letter.
Thank you.
Thank you, Dr. Klava. Dr. Glazer?
Yeah, thank you. Just for clarification, and I'm sorry if I missed it, what was the impetus for the December 21 IA interview? Had they obtained information about the suspension at that point?
No, the December 21st, 2022 interview was regarding the DUI arrest that occurred on June 1st, 2022. It was the first IA interview for that reason.
And is it just a coincidence that that occurred a day after his visit to the DMV on December 20th?
Yes, presumably.
Any other questions? Okay. Seeing none. At this time, does the subject officer and or their counsel, I believe the subject officer is present. I believe the counsel is appearing remotely. Do either of you wish to make a comment? Yes, hello. If so, you will each be given 3 minutes to speak, and the time limit will be strictly enforced. So please be ensured that you complete your comments within the allotted time. And while commenting comments, keep in mind that the board will only consider the facts as presented in the division today and will not consider any additional facts or defense at this time. The sole question before the board today is the following. If the facts offered by the division today are in fact proven at a later hearing, do those facts demonstrate clear and convincing evidence, a high probability that serious misconduct as defined by Penal Code Section 13510.8 and Commission Regulation 1205 occurred? So, officer, would you like to be heard?
Good morning, and thank you for allowing me the opportunity to speak today.
Okay.
I want to begin by saying that I completely
Excuse me, officer, I misspoke. You have at least 5 minutes, okay?
Yes, ma'am. I would like to begin by saying that I completely own the mistakes that I have made. I do not deny them or make excuses for them, but I would like to provide some context of why I'm in front of you today. I've had time to reflect on the decisions I made during the lowest point of my life. I carry the weight of those choices every single day. Plain and simple, I put others at risk and I did not conduct myself as one in the profession should, and that was unacceptable. I know I have made mistakes in the past, but I have also learned from them. I understand the difficult decisions this board has had to make, and I've read most of the misconduct you have investigated. I believe this process and your role is absolutely necessary. I also believe the board's primary concern in my instance is the issue of my dishonesty, and I don't shy away from that. I failed to live to the standards of integrity without compromise. I know better because I have never omitted or falsified information in the past, but in this instance, to save my career, I betrayed not just the department's values, but my own. Before this, I had never been in trouble and on the other side of an investigation. I was nervous and I followed legal advice that I thought would guide me through the process. But looking back, I realized I should have been more direct, forthcoming, and transparent. When I was questioned about whether I drove during my suspension, I tried to shield myself by offering partial truths. I said others drove me, which was true, but I admitted that I also drove myself. I convinced myself I was answering the questions just well enough to move past them, but omission is deception and a failure of integrity on my part. Once the evidence came out and I was asked, I admitted to it, but by then I already lost the trust of my department. I've spent most of my adult life in service. I started as an explorer with the Sheriff's Department, served for 6 years in the Marine Corps, and the past 8 years as a deputy. I've handled hundreds of investigations, served with distinction, and responded to life-threatening situations without hesitation. But I've also struggled. I've had troubles with PTSD, depression, and anxiety, issues I tried to bury instead of address. I coped poorly with those, and I had unhealthy patterns of alcohol abuse that contributed to my poor decision-making. Since then, I've done the work. I've gone through constant counseling, joined AA, remained sober, and developed healthy ways in order to manage my stress and trauma. I accepted a demotion and I worked in custody this past year without incident and was re-promoted, earning my way back to patrol with strong performance evaluations. Towards the end of this investigation unfolding, I had the opportunity to be involved in the most critical and traumatic incident in my career and in Orange County. It was an active shooter who had already killed multiple people and was firing at deputies from an elevated and fortified position. While under direct fire, I led a team to flank and help neutralize the suspect in order to begin life-saving measures. For that, I was awarded the Medal of Courage. And that day reminded me why I chose this career: to serve, protect, and act when others are in danger. The week following that incident, I was placed on administrative leave, pending terminations for my actions we're discussing today. I showed myself I had strength by not resorting to alcohol and maintaining a positive attitude. I used that time to continue the positive progress that I made, thankful to have a second chance at life and in this profession. Since returning to work, I have also taken the responsibility of mentoring younger deputies, using my own mistakes to help avoid the same pitfalls. I'm not just here to keep a job. I'm here because I want to become the kind of deputy that teaches others the value of integrity and what accountability looks like. I'm not asking for forgiveness, but I'm asking for a chance to continue serving the public and guiding others by example. I hope the board can see that I'm not defined by the worst chapter of my career, but by the growth and accountability that came after. Thank you again for your time and allowing me to speak.
Thank you. And let me ask you some rather direct questions.
Yes, ma'am.
And if you don't want to answer them, don't. But you put several things out there that I want to follow up on. You heard the presentation today. You've read all the documents. You've been accused of multiple acts of dishonesty. Are you telling us today that you in fact committed all those acts of dishonesty?
Yes, ma'am.
You also said just now that you have found ways to deal with your PTSD. Can you tell me what you did to deal with PTSD?
Yes, primarily returning to faith, attending church consistently, and exercising. Began doing endurance sports that helped me decompress and come back to reality.
Did you go to any specific therapy that deals with PTSD, EMDR, or anything else?
Yes, the counseling that I've been attending with TCTI, I've been doing that very consistently, and also tried EMDR
And how many times did you try EMDR?
twice, ma'am.
I'm sorry.
Twice, ma'am.
And was it helpful?
Yes, ma'am.
Okay. The act that you engaged in, and ultimately you ended up with the Medal of Courage, that occurred after your suspension, knowledge of your suspension, but before your suspension occurred. I was unclear on the timing of that.
The incident occurred, and then I was suspended for 6 months the week after.
Okay. The incident occurred, then you were suspended, and then when did you get the Medal of Courage?
Upon returning back to work.
Okay. How long have you, when was the last time you had any alcohol?
It's been 9 months, ma'am.
And how long ago was the incident with driving under the influence with the over 2-0?
Over 3 years, ma'am.
Okay, so at some point you stopped drinking and then you started drinking again?
Yes, I've been battling with sobriety and maintaining it consistently. It's very hard when things get difficult. It's easy to go to a drink. I've learned that and have been successful at maintaining that now, after having short relapses of a few drinks and then feeling guilty about it afterwards.
Why do you think, so after the DUI, you stopped and then you went back to drinking, and then 9 months ago you stopped. Why do you think you've been successful this time, whereas you were intermittently successful in the past?
Ultimately realizing the trouble that has caused me and the risks that I put upon other people, and leading me into this situation where I'm losing my career.
Have you ever substituted out drugs for alcohol, either prescription drugs or unlawful drugs?
No, ma'am.
So it's always been alcohol?
Yes, ma'am.
Okay. Is there anything else, and other board members may have questions too, of course. Is there anything else you want this board to know about you that you haven't said? Okay. Thank you very much for your honesty and for coming here today and telling us a little more about you. Other members of the board? Yes, let's start with Ms. Pena.
How many days sober have you had now?
Days?
Days, months?
I do not track the days. I
Okay.
try not to focus on the days of sobriety in order to just keep pushing towards them.
Okay. Did your sponsor come with you today?
I do not have a sponsor. I'm not directly involved in AA anymore. I was after the DUI.
You go to any other type of counseling program for alcoholism besides your time in AA? Do you do anything else now?
With my counselor from TCTI.
What's that exactly?
It is a organization that is partnered with our department to provide counseling for us.
Okay, how often do you go to that?
It's based on availability and it's about every month or 2 months, depending on availability.
Um, there have been various comments that you've made either on the record or through what's reported in investigations and what you've said here today about how, I think today you said you've taken full responsibility for your actions.
Yes, ma'am.
However, you submitted a written statement to us today that I actually had the opportunity to read. It's dated July 10th, 2025, which is obviously not very long ago, a week ago. And in your third paragraph, where you actually begin to talk about what occurred, the last line in that sentence says, or paragraph says, in talking about your ability to answer questions honestly about when you drove, etc., when you didn't drive, you say that omission, while not an outright lie, was misleading and not in line with the level of transparency expected of someone in our position. So in that paragraph, which is the first one where you talk about what occurred, you say an omission was not an outright lie, was not an outright lie. I mean, you talk about the investigation as if you didn't lie about anything, you just left things out. And leaving things out is a lie. So which is it?
It is a lie. An omission is deception and is dishonest.
You also say some of your reasoning for answering questions is because you were following legal advice.
Yes, ma'am.
Was the legal advice to mislead or omit or lie?
Yes, ma'am.
It was?
Yes.
You got legal advice telling you not to answer questions accurately?
Upon concluding the first interview, I realized that I had made incorrect statements. I looked back at my paperwork and realized the dishonesty of the dates that I knew my license was suspended. After that, I brought it to the attention of my attorney at the time, and I said, "Hey, I made this mistake. I believe I should tell them." He said, "Don't mention it unless they directly ask you in the future." I know that driving on a suspended was another violation after my DUI and could possibly face termination. So I went with that advice and I answered the questions vaguely and not directly.
Thank you.
When you attended AA, how long did you go for?
About 6 months, ma'am.
About 6 months. And then do you have any other support mechanisms? And I heard you say that you have the, I'm gonna say that EMDR, the counselor that you may attend once a month or every other month. But do you have any family? I heard you mention faith, that you're leaning in on faith. So do you have a pastor, a priest, a minister that you meet with regularly that provides you some emotional, mental support? Or are you leaning in on yourself to do all this by yourself? I heard you say 9 months clean, which isn't very long. You don't know the number of days, which kind of concerns me for a person who's battling with alcoholism. So do you have a support team? Do you have a support mechanism in place?
Yes, ma'am. I have a family that I resort to, as well as some friends that I directly worship together with, and that are also in the profession that can relate and I can open up to things about. Previously, I completely tried to do this on my own, and I realized it's very difficult for me to open up to other people, and that did not do well for me.
One last question. I believe I read or heard somewhere that stress, different things, and we know what contributes to PTSD. So you are in a very stressful job.
Yes, ma'am.
And any day it can go from 0 to 100. With that being said, how will you cope with the next time you're faced with some life or death or a stressful situation that may push you towards alcohol again?
Just resorting back to everything that has happened the past 3 years. I've grown tremendously from it. And I know those different coping mechanisms and the outlets that I have, whether it's counseling or friends, in order to open up to and address those issues before they become issues.
Yeah, first I want to thank you for being present today and for answering our questions and presenting your statement. And I also want to thank you for your service both to the nation and county and law enforcement. I want to get back to what Board Member Pena was talking about with respect to dishonesty in the context of omission versus. And I want to give you another opportunity to talk about whether your dishonesty took the form of only omission or if there was direct deception on your part. Because, you know, I would characterize it as if the internal affairs interviewers had asked you if you ever let your trainees drive and you said yes, that would be a deception by omission. But I think that they asked you if you drove and you said no, and that sounds more like a direct deception. And I'd like to hear your answer with respect to that and other instances in which you gave dishonest responses and whether you consider them only to be by omission.
I do not believe it only to be a omission. I believe it to be dishonest now that I have been through this investigation and I knew that. Yes, sir.
I thank you for coming and being honest with the board as I see it. I don't drink, but I do have a son that has the same issues you have. It's a difficult, it's difficult. You know, it's hereditary, runs in families, and it is a sickness. And I will always say that. But given the job that you do and, you know, the commitment of being an example, it is one of the things I'm struggling with is that, you know, we expect more for our officers. And I'm speaking from what I do is, you know, we want you to be honest because just as we want you to be honest, you expect the public to be honest. And I kind of sense that you were struggling, you know, you were giving poor advice, but I'm not an attorney. Several attorneys are sitting here, but it's common for them to tell you only answer the question and, you know, and to do that. And so you were put in a position where you sound like you were struggling, you know, between omission, dishonesty. And so right now, this board has to look at the fact of the dishonesty issue. And I'm sorry, I'm always a person that believes in second chances, but it's not only up to me, but the reason why I'm speaking is I want you to understand we are sympathetic. I am, Elise, to your struggle and that you got a long journey to do. And you're right now at a crossroads, like you said, you're fighting for your position, for your job. And I pray that you do take this and so that others learn from it.
Thank you.
So.
Deputy, I wanted to echo the board to thank you for your service both to the country, to your county. You clearly show great martial courage, obviously, even under fire, and that is not anything to be taken lightly. I obviously think that the board understands also that we need to see great ethical courage from deputies and officers that do the work. A couple of questions for you. Does, and if you don't know, it's fine to say no. Does your agency intend to keep you on as a deputy?
Yes, sir.
And how do you know this?
I signed a last chance agreement upon returning to work, stating that I was on probation period for the 2 years regarding alcohol and drug related and dishonesty. I completed my demotion period, which was a little over a year, and I have since been re-promoted, returning to patrol operations. There's nothing in there that says a termination date other than what the determination of post is.
That's all I have. Thank you.
Johnson speaking. Yeah, thank you for your service. I too as a vet. I want to think about take us back to the truck rental.
Yes, sir.
Was your license suspended when you rented the truck?
I do not recall the specific dates, but the dealership gave me a loaner vehicle while it was in the shop.
So you're not sure if your license was suspended at the time?
I cannot recall right now the dates that I received the truck and the suspension, sir.
We'll get clarity on that in a second. My next question is, you've been employed as an officer for 11 years,
No, sir. A little over 8.5.
8.5. During that time period, had it come to knowledge that one of the most important things about being honest?
Yes, sir. And during my time in the military.
Now, in that time period, did you know anyone that was going through any issues concerning being dishonest?
Not directly, but I have heard stories, sir.
So you was pretty much aware of how important honesty is.
Yes, sir.
All right. I'm gonna go back to that truck. On the rental vehicle, since you really don't remember if your license was suspended or not, what was the purpose of having a firearm in the rental vehicle?
The firearm was along with multiple firearms that I had when I went shooting, and it was misplaced inside the vehicle, sir.
So you misplaced it in the vehicle, and then when asked about it, you could not remember where it was at or what you had done with it?
Correct.
That in itself is a violation, unsecured firearm.
Yes, sir.
I'll put it there. I would like to ask about the license suspension in the truck rental.
During my review of the internal affairs investigations, it indicated that the Ram 1500 was rented in September of 2022 prior to his conviction on October 7th, 2022. The suspensions took effect either on October 7th, 2022 or October 28th, 2022.
Thank you.
So now I'm confused. At the time that he rented the truck, did he have a suspended license?
After his arrest, he had it for the admin.
I couldn't hear you.
I'm sorry.
I couldn't hear you.
Oh, after his arrest, he hired an attorney to handle his admin per se issues, and that was stayed until the court was adjudicated the case. The case was adjudicated on October 7th, 2022. That was when the first suspension took effect. A second suspension took effect on October 28th, 2022. And based on the information I reviewed in the internal affairs investigations, the Ram 1500 was given to him in September of 2022. So no license suspensions had taken effect, to my knowledge, at that time.
Okay, so I'm an attorney and I didn't understand all that. So let's be clear. So the answer to my question, unless I'm confused, is he rented it on September 22nd, and at that point his license was not suspended. Is that correct?
To my knowledge, yes.
Okay. Yes, it was not suspended.
And just to be clear, we don't know what date in September he rented it. because we did not get that information from the dealership, but it was sometime in late September of 2022. It might help to explain how the suspensions worked out.
Okay,
That
let's
might
do
help
that.
clarify. So when you get a driving under the influence charge, there are two suspensions that happen. You get a suspension as a result of the arrest, which is sometimes called an
Right.
admin per se.
Right.
That's the suspension that was implemented on October 28th. Then there's the suspension that you get as a result of a conviction when you get convicted in court, and that's the suspension that happened on October 7th. The reason why there's two is because there's an administrative one from the result, from the arrest, it's a separate proceeding. Those can actually happen ahead of time, but it depends. You can ask the DMV to basically continue your hearing out until your court proceedings finish out.
Right.
And the DMV is usually very good about doing that. So what happened here was that process was still going while he waited for his criminal proceedings to finish. And at some point, he had an issue, I think, with his truck. Mr. Patan can certainly correct me if I'm wrong. And he got the truck sometime in late September 2022, while his license was still good. And then had it until December 13th, 2022. But the suspension took place and took effect on October 7th because that's the date he was convicted in the criminal proceedings.
Yeah, I used to prosecute DUI, so I understand that. But the two suspensions, one began October 7th, one began October 28th. The car was initially rented at the end of September.
Yes.
Okay, so when you rented the truck, you did not have a suspended license. You had a license. Is that your understanding now?
Yes, ma'am.
Okay, but you had the truck until when?
It was the date they mentioned in December, I believe 12th or 13th.
So at any point when you had the truck, were you driving it on a suspended license?
Yes, ma'am.
Okay. Now, why did you drive the truck on a suspended license?
So the truck in question was not rented in order to deceive or avoid detection. It was because of the issues with my vehicle and I had it for an extended period of time. I drove because I had the obligation and to show up for work. Because I already had shown that I have caused issues with myself and with the department, I didn't want to inconvenience the department anymore, being a brand new training officer and having to be there. So I wanted to build upon my reputation and come back from the DUI that I had previously received. It's
Do
not,
you think it builds on your reputation to unlawfully drive the truck?
no, ma'am. And
Okay.
that's what I was getting at, where I now realize that I had put my partners and everybody else in more inconvenience because of everything that occurred from driving on a suspended license.
Okay. So you're driving the truck on a suspended license. You're driving into your job as a law enforcement officer, breaking the law, driving on a suspended license. You're going hunting, driving on a suspended license, correct?
Yes, ma'am.
And you're taking your gun and have your gun in your truck and the gun is not secured. Help me understand how you left a gun that was not secured in your truck. And further, when asked about where's the gun, you said, I didn't even know it was missing. This is a deadly weapon. Help me understand why you didn't know where your deadly weapon was.
That's a good question. I've been taught, whether it was in the military or as a SWAT officer, in order good weapon accountability and everything like that. With that being in mind, I have a case that secures my pistols, and there's multiple in there. And I take that when I go, and I secured it, and I brought that out of the truck. I was unaware that I had left that firearm underneath the armrest when I was clearing out my vehicle. That case then goes into a safe when I get home. And I was unsure. I should have maintained accountability and checking that they were all inside there, but I did not.
Help me understand a little more about that. For me, it'd be tantamount to leaving my child in a car seat. Oops, left the kid in the car seat. You know, leaving a gun, a loaded gun in a car, unsecured. Were you drinking when you were driving then? What was happening to your thought process? So do you have a loaded gun in a car and then weeks later not even know where that gun was?
I have no excuse. And no, I was not drinking. I have not drank and drove since I was arrested for it, and I will never do that again.
So you can't help me understand a little more about your thought process, just you forgot.
Yes, ma'am, I don't have any excuse.
Okay. Anything else? Yes.
Yes.
Dr. Go.
You stated that you signed a last chance agreement. When did you sign that?
It was in the beginning of 2024.
Can you give me some insight on that last chance agreement? Were you not supposed to have any alcoholic beverages from that time on? What was the stipulations of that last chance agreement?
From the top of my head, it is no violations of policy regarding alcohol, relating with alcohol, drug use, or dishonesty. No complete abstinence from alcohol use. But
No complete, or you were to have complete abstinence from alcohol?
it did not mention anything about that.
Okay. And then I think I just heard you say that the gun was in an armrest. Is that what you stated? That it was in an armrest, the gun that was found in the Dodge Ram? Or was it under the seat?
It's a truck with 3 front seats where the middle seat folds down, and it was underneath that.
So it raises up and it was placed under that where it raises.
Yes, ma'am.
Is it a normal practice for you or habit of yours that you put I'm a gun owner. I own several guns. I just went shooting the other day. So I'm very, I'm into it. So is it a normal habit? Because I know where I place my guns when I come from the range, and you stated you were coming from the range. And so is it a habit for you to have your loaded Glock with 15 rounds and one in the chamber and place it under the seat, a fold down seat that's in the front seat next to you? I mean, I'm sure you're a concealed weapons carrier, but still my question remains.
No, ma'am. That was the loaner vehicle that I was not familiar with. This is why I did not normally place it there, nor check it after.
Okay, thank you.
Going back to driving to work, you had stated in your interviews that you had a trainee or partner that drove you to work. And of course, the individual at some point said he didn't remember doing that at all. Did you ever have a conversation with him about you was going to make that statement?
No, sir. But I was told not to discuss with anything regarding my interview with anybody that could be involved. That's all I have.
So just out of the blue, you said Morales, I forget his name, I think it started with an M, drove you to work.
During my license suspension, there was multiple times where I used him as a close friend in order to drive me multiple places, to include that.
So maybe I'm not clear. I thought he had mentioned that he was unaware that he had driven you to work.
Yes, sir. I don't have a reason for that. His answer. He was questioned 3 years after the incident.
Do we have clarity on that?
His interview took place in March of 2025. This time period that we're talking about, it would be in October through December 2022. So this resulted when his attorney asked a clarifying question and asked that he ever given rides to Mr. Bertrain during the time period of his suspension or while they worked together at the Stanton substation. His answer was, not that I can remember.
It just sounds pretty strange. I'm sure he was aware of your situation. And he had the opportunity to also be dishonest, and he chose not to be. So it's just kind of curious to me that a good friend of yours would not remember driving you to work. And so About when you said that you've heard other officers get in trouble by being dishonest. And it appears to me you continue to bury yourself in the situation that you was trying to get out of. I'm just trying to get a better understanding of why. I mean, you were clear at some point that you were being dishonest and you continued to be, and then you brought other folks in, hoping them to help you in many ways cover up the dishonesty. I think you put your friend in a very odd position, his career or you, and he chose his career. Well, learn something from this.
Yes, sir.
Okay, couple of housekeeping things. Court reporter's been at it for an hour and 18 minutes. So there are two more things I'd like to do on this case. One is I want to check with board members to see if you have any other questions at this time. The other thing is I want to give his attorney an opportunity to speak and an opportunity for you to ask questions. So just to give me a sense of timing, do you have any more questions for the officer? No, okay. And let me check. I'm sorry, I don't know your name. The attorney here?
Kylie?
Yes, ma'am. Kylie Coleman with Ferron Law Group here.
Okay, and would you like to use 5 minutes to speak?
Yes, ma'am.
Okay, then what I'm gonna do is I'm gonna give the court reporter a break. And when we come back, you'll have your 5 minutes. And then if the board has any more questions or comments, we can resume that after you speak. Okay, so it is now 10:18. Let's come back at 10:28. 10 minutes. Thank you, everyone. Okay, back on the record when you guys are ready. And we'll get the attorney back on. Wonderful. I had another question during the break because my understanding is that the DUI occurred on June 1st, 2022. Does that sound about right?
Yes, ma'am.
Yeah. And you rented the car in September. So explain to all of us. So on June 1st, you got the DUI. And tell me if any of this is incorrect. So I'm just trying to remember back to when I prosecuted DUIs. You had to hand over your regular license to the police officer who gave you the DUI. Is that correct?
Yes, ma'am.
Then he gave you a paper DUI. Excuse me, I'm sorry, a paper license.
Yes, ma'am.
Okay. And then that paper license was only good for 30 days. So you or your attorney or somebody, and again, correct me if I'm wrong, had to get an extension so that beyond July 1, you had a valid license. Do you remember any of that?
Yes, ma'am. My attorney filed for an extension.
Okay. So you knew that did you know how long that extension was good for?
No, I heard that it was still backed up from the time during COVID. And
I'm
then
sorry, say it again?
I was told that the hearings were still held up from COVID and were delayed. So
Ah.
it was possibly going to be just before or after my court case.
Okay. So and then your court case was October 28th. And so there was that. So you rented the truck on September 22nd. At that point, you were still under the extended license. And so you knew at some point you were going to be convicted of a DUI and it was going to have some ramification to your license. Help me understand why you rented the truck if you had a car.
My truck had issues, major electrical issues. So I brought it to the dealership where they gave me a loaner vehicle, not it is a rental, but a loaner vehicle from the dealership.
So this Ram truck that you rented was something that the company that was repairing your truck gave you some kind of voucher to go get another one while it was being repaired?
It was a loaner vehicle from the dealership, ma'am.
Okay, so this was the loaner vehicle.
Yes, ma'am.
Okay, that's where my confusion was. So at that point, you were still on the, for lack of a better term, the extended license, but you knew something was going to be happening in the future with your license. You just hadn't been given that legal determination yet. Okay, thank you. Any other questions on that? Mr. Johnson, go ahead.
And help me understand too. I've never been put on for DUI, so I don't understand the process, but I have a nephew that has. And I think he had told me it took a couple of times before he actually lost his license. So my question is, was this your first DUI?
Yes, sir.
And maybe for clarity, I guess if you stop under the influence and it's a DUI, you automatically loses your license. Is that correct?
There's an admin hearing through the DMV that determines their suspension, and then the court hearing that determines that suspension. It's not automatic, but yes, eventually it could be, or it could be overturned.
Why would it be overturned?
If the officer did not have a probable cause to make the stop, if it was not a good stop in the first place, or they did not drive under the influence.
If the driver wasn't under the influence, but you had a 2.0 or more.
I was, sir.
Okay. So it was obvious that it was a DUI, and then the officer was procedurally correct in making the stop. So all that was correct. It was just a matter of your own personal issue now with how to deal with this DUI. And I think you make a petition to the courts or the DMV to extend, is that correct? Or to get a temporary license?
Yes, sir.
And you did that within a time frame? How quick did you do that?
I do not recall specifically how quickly I did it because my attorney did it, but you have up to 30 days to complete it.
Okay, and I think that's the extension you were speaking of? Okay,
So for 30, my understanding is that the time the license is physically taken away, the license we all carry, you have 30 days to go back to DMV to get the extension, and that's what happened here. That's my understanding.
And so, board member,
Yes, go ahead.
for clarity, what I learned working with the DA and a former DA, that each county is different in terms of how the process worked. Ventura County is totally different. And then you have that other element of the DMV, which is totally different. And the only reason why I wanted to provide some clarity to that, and it's funny, and I'm trying to make light of this, is I just discovered that my license was suspended 2 years ago, but the DMV didn't know it. And when I went back to ask them, they're like, oh, we have never seen this. So people need to understand in context that when you're working with two different agencies, it's a little different. And then in counties, it's different. And so that's not to excuse anything. Point in case is the fact is that on September 22nd, what I'm hearing from your knowledge is you thought you had violent license and you went to the dealership. And I know I love going to the dealership and getting the rental cars there. They give them to you. And sometimes they don't check. And so I just wanted to point that out. Board Member Johnson, that was it.
Thank you. Okay, now, your attorney, we're going to be hearing from your attorney now. Please go ahead.
Thank you, ma'am. Good morning, board members. My name is Kylie Coleman, and I represent Deputy Jared Brittain. I want to thank you for the opportunity to speak today. This is a case about accountability, transformation, and the ability to rebuild trust after failure. My client made serious mistakes. There's no question about that. Those missteps, driven by personal struggle and deep shame, compounded into the dishonest conduct we're here to address today. Deputy Brittain does not deny it. Instead, in his Skelly hearing, he stood before his department with no excuses, just honesty, context, and the sincere desire to take responsibility. Deputy Brittain explained the context of his actions, untreated PTSD, and a reliance on alcohol that fueled his shame and poor decisions. However, he didn't deflect, he owned it. He submitted over 20 letters of support from colleagues and community members, all affirming his strong character. One of the most powerful came from his therapist, who described the initial investigation as his rock bottom. Once seen as one of the deputy's best, he had been suffering silently, but instead of continuing down that path, he got treatment, regained his health, and reconnected with his purpose. The therapist noted that while sobriety is part of his healing, true change came when he took full accountability. The department made the decision it rarely takes. It rescinded its determination for a termination and gave him a second chance. Deputy Brattain accepted a demotion gratefully and simply said, "Don't take my word. Let me prove to you who I am now and who I'm working to become." He then voluntarily proposed a last chance agreement, holding himself to the highest standard. If he violates any policy regarding dishonesty, alcohol, or drug use, he will be immediately terminated. He put that promise in writing on February 22nd, 2024, and he has lived up to that promise every day since. He served over a year as a Deputy 1 in custody without a single incident, like he noted, earning strong performance evaluations throughout, and was later re-promoted to his Deputy 2 position and reassigned to patrol, where he remains today in good standing. He was a model deputy with no prior discipline, and since this incident over 3 years ago, he's proven that he still is. Deputy Brattain mentors younger deputies, speaks openly about his past, and reinforces that integrity isn't about being perfect. It's about owning your failures and proving you've learned from them. Again, the post standard of integrity without compromise. And commissioners here, I understand, as does he, your duty to protect the credibility of this profession. But I ask that you look at the full picture, not just the lowest point, but the growth and commitment he has demonstrated since. The department he has served faithfully for over 8 years continues to stand by him. He's earned their trust back, and we are respectfully asking you to allow him the opportunity to earn yours. Deputy Brattain is not asking for leniency. He's asking for a chance to prove your trust won't be misplaced. If it takes probation, check-ins, additional training, or a temporary suspension, he's willing to accept whatever conditions you find appropriate to demonstrate that the man who is standing before you today is not the man who made those mistakes. And we thank you for your time and commitment to this profession and for considering his future in it. And that's all I have.
You have the last chance agreement in front of you?
I do, ma'am.
Okay. When was it signed?
It was signed on February 22nd, 2024.
Do you know what it said about alcohol use?
Yes, let me pull it up. Are you referring to whether there's any restrictions on drinking in its entirety, or
Anything about alcohol use?
alcohol use personally? No. It only touches on the fact that if there's any sustained allegation of dishonesty, any sustained allegation of misconduct where alcohol was a factor in Deputy Brighton's behavior, or where the violation of any alcohol-related policy, and then similarly for any controlled substance.
Okay, so misconduct that was alcohol related or
Or where the violation of any alcohol-related policy.
okay, so there was nothing in there about that he has to stop using alcohol, or he can't drink at all, or he has to stay out of places where alcohol is the main form of blah, blah, blah.
No, ma'am, that is not in this agreement.
Oh, no, so no abstinence at all.
Correct.
Okay. Any other questions for the attorney? Yes, I think let's go with Dr. Glazer, then Dr. Cava.
Thank you. Ms. Coleman, you indicated that the last chance agreement requires a sustained finding with respect to the various categories of offense. Is that true? So that it would require an internal affairs investigation and a sustained finding in order for his position to be revoked?
Correct. A sustained finding of dishonesty, alcohol, or drug use would be an automatic termination.
I want to go back to the EMDR. That's the only therapy you're in, correct?
No, I'm in the normal therapy with my therapist that I do see on a regular basis. I just tried EMDR for the PTSD.
Okay, then let me go back because I may have missed that earlier. How often are you seeing that therapist?
Every 1 or 2 months. When it was at the height of this whole incident, I was seeing her every 2 weeks. But since have stepped back to every once a month or every 2 months.
You've been going there since 2022 or
Yes,
just recently?
it's been over 3 years.
Over 3 years. Okay, no question.
Johnson.
Anything else? Yes, Mr. Johnson.
So you signed a last chance agreement pertaining to dishonesty or alcohol. Is it for 7 years or is it for a lifetime? Or career time, I should say.
Those specific allegations is a 2-year waiver of his rights if any of those sustained, as I noted, are violated. And then that is the 2-year waiver, sir, to answer your question.
So that expires to 22/26.
Correct. That would be then February 22nd of 2026.
Okay. Anything else?
I guess my last question would be, was there given a choice of time length to determine on whether you would sign that last chance? In other words, was it offered that, or did you propose the 2-year yourself, or could you have chosen 5 years?
That is what the department and county council provided with me. No back and forth with it, from my understanding, sir.
Would you be willing to do 5 years?
Would do whatever time was necessary to maintain my profession.
Else? Okay, anything else, council?
No, ma'am. Thank you.
Okay,
And thank you, board.
Okay, thank you for coming forward. Would you like to go into discussion? Okay, we'll take a few minutes now and go. Public comment. Oh, is there any public comment? There was somebody on the.
Yeah. Right here. The gentleman raising.
Okay, is there a Mr. Gill?
Yes, the level of standard for this officer is abysmal. He's made multiple mistakes time and time again. Other regular citizens aren't held to this kind of standard. The racist remarks, the DUIs, firearms in the seat, unsecured, PTSD, emotionally unintelligent. That's all. Thank you.
Mr. Gill? Mr. Gill, are you still there?
Yes.
I, first, thank you for calling. You said something about racist comments by this officer or just officers in general. Do you have any allegations you want to bring forward about this officer or just officers in general?
This officer.
Well, what is it you want to say, Mr. Gill?
Actually, I'm saying officers in general. Yes.
Okay. Is there anything else about this officer that you'd like to say?
Well, yes, the DUI, the PTSD, the loaded firearm in the seat, emotionally unintelligent. How can someone with PTSD and someone who struggled with sobriety be able to carry a loaded firearm and deal with the public?
I understand. And,
uh, along with dishonest paperwork and lie time and time again. The integrity is not to lie, not you get caught and then you take responsibility for it. It's taking responsibility for your actions. He's he's a dishonest officer.
yes, yes, he has been a dishonest officer, and that is something that he has told us today and something we have seen, as you have seen in his past. And we thank you for your call.
Thank you.
Bye.
Madam Chair, do we want to, I want to identify the public call.
His name was Salvador Gill? Yeah. At the court reporter, got it. Okay. Salvador, I thought.
Here. It was FILK.
Just for clarity, they're not required to identify themselves,
Yeah.
so it's not an issue. We can just say public comment.
Yeah. Okay, let's go into chambers, or whatever that is. Into the conference room. We will now reconvene to regular session to take a vote on the board's recommendation in the matter of case post 2316745, Jared Bertain, who at the time of the events at issue in this case was employed with the Orange County Sheriff's Department. Does the board have any comments in this matter? Is there a motion to make a recommendation to the commission in this matter?
Johnson, recommend, recommendation, decertification.
Is there a second?
Second.
And Chandler, can you take the roll?
Yes, Madam Chair. Clavo,
Aye.
Clavo, I, Crawford. Crawford, I, Dudley.
Aye.
Dudley, I, Glacier.
Aye.
Glacier, I, Johnson.
Aye.
Johnson, I, Lara.
Aye.
Lara, I, Pena.
Aye.
Pena, I. That's 7 yeses. Motion carries.
Motion passes. Okay, now we're going to call the second case. At this time, I will now call upon law enforcement consultant Scott Bayland, Professional Conduct Northern Bureau, and Brian Hoffman, Attorney for Legal Affairs Bureau, to provide a report on case post 2318309, Robert Sazek, who at the time of the events at issue in this case was employed with the Oroville Police Department.
Good morning, Chair and members of the board. My name is Scott Bayland, and I'm one of the law enforcement consultants assigned to Professional Conduct Northern Bureau in the Peace Officer Standards Accountability Division. With me today is Brian Hoffman, an attorney with our Legal Affairs Bureau. I'm here today to present case number post 2318309 involving the respondent, Robert Sasek, formerly an officer with the Oroville Police Department. It is the division's determination that clear and convincing evidence exists to demonstrate that the respondent committed an act of serious misconduct as set forth in Penal Code Section 13510.8 on September 1st, 2022. Specifically, the division has determined that Robert Sasek committed the following act of serious misconduct. Penal Code Section 13510.8, subsection B, subsection 2, abuse of power. In this presentation, I will present a brief outline of the division's findings of investigation in this matter. The respondent began his career as an officer with the Oroville Police Department on April 28th, 2021. The respondent received a 30-day suspension and a 90-day performance improvement plan penalty as a result of the Oroville Police Department investigation into this incident. Later, the respondent was terminated from Oroville Police Department on August 9th, 2024, resulting from an investigation into a separate incident, not a post-related matter, and the respondent currently possesses a basic post certificate. There is no other relevant discipline or complaints against the respondent. Can you start with the timeline? On September 1st, 2022, at approximately 13:30 hours or 1:30 p.m., the complainant was arrested by Butte County Sheriff's Office for trespassing on private property when she was found swimming in the backyard pool of a private residence. The complainant was transported without her shoes or purse to Butte County Jail and was later booked. The complainant stated in her interview that she had taken methamphetamine earlier in the day, was feeling the effects of the narcotics, and was hot and dehydrated, explaining why she was in the pool. The complainant was released from the jail at approximately 16:17 hours or 4:17 p.m. At approximately 20:52 hours or 8:52 p.m., the complainant entered a Dollar General store in the city of Oroville and began hiding under some merchandise carts in the back storeroom. Employees called and requested Oroville Police Department for assistance. The respondent was dispatched to the Dollar General at approximately 20:53 hours, 8:53 p.m. The respondent arrived on scene at approximately 20:55 hours, 2 minutes later. The complainant was ultimately arrested by the respondent for trespassing at approximately 21:21 hours, 9:21 p.m., after removing her from underneath the carts. The respondent transported the complainant to Butte County Jail. The Butte County Jail nursing staff refused the complainant for booking because she was experiencing high blood pressure and required her to get medical clearance prior to booking. The respondent began transporting the complainant to Oroville Medical Center at 21:43 hours or 9:43 p.m. The respondent arrived at Oroville Medical Center 5 minutes later at 21:48 hours and entered the emergency room. However, the respondent did not bring the complainant in for medical treatment. Instead, he left her in the patrol vehicle. The respondent returned a short time later, removed the complainant from his patrol vehicle, and cited and released her and told her she needed to seek medical treatment because that's why she wasn't booked. The security guard at Oroville Medical Center, who was a former Oroville Police Department officer, advised Post in his interview that he told the respondent that the complainant was going to continue to be a problem. Next slide, please. The respondent left Oroville Medical Center on his own at approximately 22:01 hours, 10:01 p.m. Immediately after the respondent left, the complainant began attempting to access restricted areas of the medical center and locked herself in an employee-only restroom in a restricted area. The security guard advised that the complainant exit the bathroom after multiple commands and announcements. The security guard advised the complainant then ran and got underneath an MRI trailer and refused to come out. The security guard called the respondent back to have him respond to the medical center to deal with the complainant. The respondent was dispatched back to the medical center. This call came at approximately 22:11 hours, 10:11 p.m., or 10 minutes after the respondent initially left the medical center. When asked, the security guard stated based on his experience as a peace officer, he believed that the complainant was under the influence of methamphetamine at this time. The respondent returned to the medical center and arrived at approximately 22:13 hours, 10:13 p.m. Sergeant Khan, his supervisor, also arrived on scene around this time. The respondent was able to get the complainant out from underneath the MRI trailer. This was the second time respondent had to remove the complainant from underneath a structure or item. During this encounter, neither the respondent nor Sergeant Khan had their body-worn cameras activated. The respondent walked the complainant back to his patrol vehicle and placed her in the back seat of his caged patrol vehicle. There are conflicting statements about whether or not the complainant was handcuffed or not at this time. Around this time, a separate officer, Officer Isaac Herrera, arrived on scene and parked near the respondent's patrol vehicle and remained seated in the driver's seat of his patrol vehicle. The respondent and Sergeant Khan stood at the driver's side door of Officer Herrera's patrol vehicle. At this time, it was decided that the respondent would transport the complainant to Chico, where she resides. The respondent admitted that he was frustrated that he was going to have to drive the complainant all the way to Chico. Officer Herrera stated he also observed that the respondent seemed frustrated, and he said he made a joke or a comment that the respondent should, quote unquote, drop that bitch off on Neal Road. Officer Herrera stated the respondent definitely heard the comment because he smirked afterwards. Officer Herrera stated that Sergeant Khan also heard the comment and just shrugged his shoulders in response. When asked in follow-up interviews, both the respondent and Sergeant Khan stated they never heard the joke or comment, even though, according to Officer Herrera, they were standing in close proximity and less than a foot away from him at the time the joke or comment was made. At 22:18 hours, 10:18 p.m., the respondent provided Oroville Police Department dispatch with his beginning mileage to an unknown location in the Chico area. It was at this time the respondent attempted to restart the RIMS application on his work cell phone in an effort to reboot that system because he stated he had been having issues with it throughout his shift. RIMS is known as Records Information Management System, is an application to receive computer-aided dispatch logs and also has the function to send messages to dispatch and other officers. It runs as an application on a cell phone and doesn't interfere with the cellular phone's capabilities to make or receive calls or text messages. The respondent never reported having RIMS issues to anyone that day, including Sergeant Kahn. At the time of transport, respondent still had not activated his body-worn camera. The respondent then began transporting the complainant towards Chico. After approximately 15.5 miles, and as they approached Neal Road, and just as a reminder, this is the same location mentioned by Officer Herrera's comment, the respondent stated that the complainant's mood/demeanor changed and she demanded to be let out of the patrol vehicle. The respondent exited onto Neal Road and traveled in an easterly direction. The respondent stated he pulled over near the entrance to the old worm farm, which is approximately 0.6 miles from Highway 99. And if you can go to the next slide, please. It's hard to see on here, but there's a distance measurement. That area to the left is the entrance to the worm farm. To the right is Highway 99. And it's, according to my calculations, which is a straight line, it's 0.63 miles.
Just a question, is it literally a worm farm or is this referred to as?
It was formerly a worm farm, and that's such a thing, I guess. I've never heard of it myself. After the Paradise Fires, it was burned down to my knowledge and never reopened, so it's just
Thank
a
you.
vacant. And if you could do the next slide, please. This is the entrance to the worm farm and Neal Road showing there east and westbound. As you can see, just kind of a dirt shoulder, no overhead lighting from the business or anything like that. The respondent stated he opened the rear door of the caged patrol vehicle and the complainant exited and began shouting expletives and mother effing him, as he said, towards him and kicking rocks. When asked, the respondent stated he didn't think to activate his body-worn camera to capture the complainant's alleged actions. The respondent stated he thought to himself, bye, and got into the patrol vehicle and left the scene. When asked, the respondent stated he did not try to contact Sergeant Kahn or the Oroville Police Department dispatch, either by radio or cell phone. Respondent stated that there's always radio problems when traveling towards Chico, but he admitted he did not attempt to utilize his radio to see if he could successfully broadcast information. The respondent also stated that he didn't attempt to change radio frequencies to possibly contact an allied agency, even though he stated and others have stated that that is a capability of the radio system. The respondent also stated he did not attempt to use either his personal or work cell phone to contact dispatch or Sergeant Kahn because he didn't think about it, even though he stated he has contacted them previously by that method. The respondent began traveling back towards the city of Oroville and reactivated his RIMS as he re-entered Oroville area at that time at approximately 22:47 hours or 10:47 p.m. And he put out any mileage from his transport of the complainant. The respondent stated in his interview that he didn't document what the actual ending time or mileage was when he dropped the complainant off on Neal Road. Instead, he just provided what the mileage was as he re-entered Oroville. The respondent advised Sergeant Kahn in person that he had dropped the complainant off on Neal Road, but didn't explain the circumstances that led up to him dropping her off. Sergeant Kahn stated in his interviews that at the time he thought Neal Road was the location of a well-known homeless area called the Estates. And he had known, and had he known it was a dark, desolate location with no services, he would have made the respondent return to Neal Road and provide service to the complainant. When asked, Sergeant Kahn stated that the respondent never advised him of any issues with RIMS that day, and there were no other reported issues with RIMS by other officers. When the respondent was asked why he didn't reach out to Sergeant Kahn or dispatch, the respondent said he just didn't think of it, and in hindsight, he should have. The respondent stated the reason he left the complainant out on Neal Road was he felt it was a courtesy transport, and he didn't feel he had the authority to keep her in his car. When questioned about his responsibility for getting the complainant to a safe location because she had been experiencing medical issues that required treatment and was under the influence of a narcotic, he stated that she had been making good decisions and felt she could care for herself. However, when asked in his interview by Post, the respondent admitted that he left the complainant in a worse position than when he took her into his care or custody. And he stated he didn't offer to contact anyone for her or to let her use his cell phone prior to leaving. When the complainant was interviewed by Post, she had a conflicting account of the circumstances as they reached Ninian Road. The complainant advised when she was being transported, she thought she was being taken to a hospital or somewhere else to receive services. The complainant advised she was still experiencing dehydration and was still feeling the effects of methamphetamine, so she was laying down in the rear seat of the caged patrol vehicle. The complainant stated as she felt the patrol vehicle exiting the freeway on Neal Road, she realized that they were heading towards Paradise, not Chico, so she asked the respondent where they were going or where he was taking her, and he replied, "Just shut the fuck up." The complainant stated that the respondent pulled over, exited the patrol vehicle, opened the door, grabbed her arm, and had her exit the patrol vehicle. According to her federal lawsuit, the complainant alleged that she was dropped off on Neal Road at the Neal Road Waste Facility, which is approximately 1.1 miles from SR 99 and about a half mile further east from the worm farm. And if you can go to the next picture, please. It's kind of hard to show the distance. The point to the right is the worm farm, and now the point to the lower left is the waste facility. The complainant stated she asked him, "You're just going to leave me out here?" And the respondent replied, quote, "You're not my fucking problem anymore. Deal with it," and left the scene. The complainant was left on Neal Road during hours of darkness with no shoes, no purse, no cell phone, and no available services. Neal Road, as you have seen, is a two-lane road that is situated in the east-west direction. There are no overhead lights, and the only businesses in the general area are Franklin Construction and the Neal Road Waste Facility, neither of which were open at this time of night. If you could go to the next slide, please. Again, this just shows those two. On the bottom right is the waste facility. Kind of in the upper middle is the Franklin Construction. And again, the worm farm is over on the left-hand side of the screen. The complainant stated she was scared, still feeling the effects of methamphetamine, experiencing anxiety, and was feeling nauseous because she had just got left out in the middle of nowhere in the dark. So she started walking back towards the way they came, towards Highway 99. The complainant stated she walked for about 5 minutes and then heard an oncoming vehicle. The complainant stated she turned around, saw the vehicle headlights, and then felt an impact of being hit by the unknown vehicle. The vehicle did not stop to render aid. The complainant stated she flew into the embankment, hit her head on some rocks, and was in and out of consciousness until the next morning, September 2nd, 2022, when she climbed out of the embankment and entered the grounds of Franklin Construction, where an employee called 911 at approximately 0934 hours, 9:34 a.m. If you could show the next picture, please. The arrow in the middle kind of shows where she was found on the site of Franklin Construction. And the next one, please, again. This is a closer look at it. Again, the worm farm's on the upper left. The construction and the waste facility would be kind of off our screen down on the bottom. And then she was found near some water tanks on Franklin Construction. The employee that reported the complaint was on their property and appeared to be on something, quote unquote. The complaint was ultimately transported to Enloe Medical Center, where she was admitted for her injuries. The California Highway Patrol was never contacted to complete a traffic collision report for the hit and run. The respondent completed his Dollar General arrest report the next day, which is September 2nd, 2022, and did not mention anything about his interaction with the complainant at the Oroville Medical Center or the subsequent transport to Neal Road because the respondent felt that they were two separate incidents. However, no other type of incident report or documentation was prepared by the respondent for the incident at the hospital, nor the transportation of the complainant to Neal Road. In his Dollar General arrest report that was completed the following morning, the respondent stated he felt the complainant was under the influence of a central nervous system stimulant, and this report was approved by Sergeant Kahn. As a result of being left on Neal Road and getting struck by the unknown vehicle, the complainant suffered major injuries consisting of multiple contusions and lacerations, a ruptured small intestine, which caused internal bleeding, The complainant had to have over 1 foot of her intestines removed. She had 30 to 40% of her colon removed. She had to use a colostomy bag, and she spent 7 days in intensive care and in total almost a month at Enloe Hospital. The complainant developed sepsis from her injuries and ended up having to have 2 of her toes amputated. The facts that I've just recited support the division's finding that the respondent was involved in serious misconduct, specifically abuse of power. For purposes of the division's analysis, clear and convincing evidence means evidence of a charge is clear and convincing so long as there is a high probability that the charge is true. The evidence need not establish a fact beyond a reasonable doubt. The division recommends that the respondent's post-certification be revoked. The division's recommendation is based on the following. The respondent's actions during this incident were inexcusable and were performed out of frustration from having to deal with the complainant on multiple occasions. The willful and deliberate act of leaving the complainant in a dark, desolate area without shoes, with no means of communication or availability of services, all while she's experiencing mental and/or medical issues from narcotics, was significantly egregious, displayed a wanton disregard for public safety, and was a complete dereliction and neglect of his duties and oath he took as a peace officer. The respondent purposely took the complainant to this location approximately 15.5 miles away as a means of removing her from the city of Oroville and to ensure he and the Oroville Police Department wouldn't have to deal with her again that night. In an effort to conceal his actions, the respondent deliberately failed to implement any of the safeguards he had available to him, body-worn camera, radio system, and 2 cell phones during this incident, and did not provide written documentation of the incident at Oroville Medical Center and the resulting transport to Neal Road. These safeguards were supposed to be utilized to ensure the safety of the public and the officer by accurately documenting and capturing the actions of all involved parties. As a result of the respondent's actions on this date, the complainant suffered life-altering injuries, which required lengthy hospitalizations and multiple surgeries, including the amputation of 2 of her toes. The complainant filed a federal civil rights lawsuit against the city of Oroville, the Oroville Police Department, the respondent, and some others. The city of Oroville settled the lawsuit for $3 million. In closing, the complainant stated in her interview to Post that even after this incident, she doesn't have any hard feelings towards law enforcement and believes that there are good cops that do what they're sworn to do. She further stated, and this is a quote, "Regardless of what kind of situation I was in, if I was on drugs or not, I am still a human being and I should be treated like a human being. And for me to be left out there in the middle of nowhere with medical issues and for this to happen to me, it shouldn't have happened because I'm a human being and my life is valuable. I believe that he put me in a worse situation than I was already in, and I don't understand it. I never got an answer why, because he tried to cover up everything that he did. I want to thank you for your time this morning and your consideration of this case. And with that, I'm happy to answer any questions the board may have.
Thank you. Couple of questions I had while I was reading all this, and appreciate your presentation. I especially appreciate the interview at the very end of your presentation. It gave us all more insight into the complainant. Was there ever an investigation as to whether she was hit by a car?
No, Butte County Sheriffs, when they were out there the next morning, they walked the scene to look for vehicle debris and didn't find any, but that's assuming that glass broke or a mirror broke. If it's a glancing blow off a fender, it wouldn't necessarily leave any debris. And as I mentioned, the California Highway Patrol normally would get called out in a situation like that to investigate the traffic collision, and that did not occur.
So no one called CHP?
Correct.
Okay. And did the physicians involved form an opinion as to the mechanism of injuries?
We did not obtain the medical records for that, so I don't know if they made a determination. This is all based on the complainant statement.
So we don't have any other insight into, I mean, that was quite a collection of injuries and somewhat confusing collection of injuries, and no one opined as to how she got them?
We did not know.
Okay, thank you. Any other questions by other board members? Yes.
One point of clarification, when you said that she believed she was being transported to a hospital, She thought she was being transported to a hospital in Chico. Wasn't that correct?
When she first got put in the patrol vehicle, she assumed she was going either to the hospital or to Chico. She didn't, somewhere to get services because he had already told her before that she needed medical services.
Do you know if she ever, because she was suffering from high blood pressure, which obviously can be very serious. Was she ever checked that day any place for her high blood pressure and treated?
So when she was at the jail from the initial arrest, they determined she had high blood pressure. That's why they told her that she needed to go to the hospital to get medical clearance. She was never brought into the hospital. The respondent left her in the patrol car instead of taking her into the hospital.
She also complained of dehydration, which also can be very serious. And wasn't it over 100 degrees that day?
She said it was over 100 degrees, and I did a cursory check of on the internet, and it was a summer day in September. It was over 100 degrees that day.
I don't think she complained about the dehydration until the later interview. I don't think that there was any indication she complained about it that day. Am I wrong?
In our interview with her is when she said she was dehydrated
Right.
that day.
Did anybody ever offer her water?
Not to my knowledge.
I mean, it's a hot day. She's in the back of a patrol car. One would think she might
I don't
be
think we
offered
know if they did or didn't.
if she was offered. I mean,
Nothing in the
apparently,
report said she was offered up water, but that's just
yeah.
my assumption.
I
Is
mean,
that she was not.
apparently it's why she was in the bathroom at the hospital to get water, and why she was in the pool initially was because she was hot.
She did state that's why she was in the pool. Well,
That's according to her. And
Yeah.
according to her, that's why she was in the bathroom, was to drink water out of the faucet.
But again, I think we just got the end interview, the most recent one conducted by this officer.
Yes. I think she also said in her interview that when she about regarding her toes being removed, that at one point the doctor, they wanted to remove a foot, but she argued against that, and they ended up just removing her big toe.
yeah, I know she had developed sepsis, and
Yes.
at one point she said that her daughters got called because she was actually looking at maybe life-ending injuries or
Right.
medical illnesses. But she said that the doctor tried a couple different things, and I think that's what was able to save her foot and just only lose a couple toes.
And her daughters were looking for her that evening, were subsequent to that, correct?
After this incident, yeah,
Okay, they were calling around trying to find her, right?
correct.
And they were in Chico?
I don't know that for certain. I'm assuming that general area, Chico, Orville, but I don't know where they live.
Because that's where she lived, apparently, right?
Correct. I don't know if she resides with either of her daughters or not.
Okay, all right, thank you.
Thank you. Any other questions from other board members? Dr. Blazer?
One question, this person is referred to as a complainant, but is that in reference to the civil suit that she's engaged in, not in reference to her standing with Post?
Correct. Yeah,
Okay.
I mean, complaining, we were toying with victim or, just without naming her.
But this case came to Post through the agency,
Correct.
through Oroville.
Yes.
Another question I have is Neil, does anybody know if Neil Road is, has a reputation as a particularly desolate area? I mean, it's interesting that Officer Herrera suggested it, and then that's where the complainant ended up. Is there any background on Neil Road that we should know about? Because it keeps coming up.
I mean, not to my knowledge. I mean, it is desolate, as you've seen in the pictures. And if you could just picture that at 10:30-ish at night, with no streetlights, I would just assume very dark. I've never driven out there at that time. Again, the only businesses out there are an old abandoned worm farm, Franklin Construction, and then Neil Road Waste Facility, or, like, for lack of a better term, a dump. So
Oh, no common lore about Neil Road.
not that I know of, no.
And then I was unclear on the purpose of the transport to Chico. It sounded in one part that I read, like it was just, the mandate was just to take her to Chico because that's where she's from. And there was a question about whether that was to a medical facility or not. Is there any clarity on
From
that?
what I read, it doesn't seem like they really knew where they were gonna end up. And speaking from my experience in law enforcement, a lot of times if you're going to an unknown area, you'll get there and then you'll find a place that has services available at that time of night. So I know in some of the other statements that were made by Sergeant Khan and some others, like oftentimes there's like a Home Depot there that they tend to drop people off at, but again, at this time of night, that wouldn't have been open either. So.
There was also this thought that she would not know the address, the physical address, but she might be able to point out as she got closer. Anything else?
Johnson. I thought maybe for clarity, Neil Road, one of the officers said was a homeless camp.
So Sergeant Khan said he believed that where Neil Road was at, where he was told she was dropped, was a homeless encampment. He didn't know, that's what he suspected it was. That's when he said, I dropped her off on Neil Road, he assumed it was this homeless encampment.
Okay. First question, what's the distance to nearest services from where she was dropped off at?
I couldn't even tell you because I'm not familiar with that area, but I know the city of Chico was only about another 1.5 miles, 2 miles away. So I would imagine there would have been services there. Coming from Warrenville, I'm not sure if there were services prior to that. But again, if the intention was to go to Chico, another 1.5 miles, 2 miles would have put him in the city proper of Chico.
Is that a dirt road by chance?
Is what?
Neil Road.
It's an asphalt road. It's 2-lane asphalt road. There's dirt shoulders.
So RIMS, what is that?
So it's a records information management system. So as I said, it's an application on your cell phone that you use, and they use it in law enforcement. It's a means of communicating with dispatch. You get your calls sent to that phone. It's a CAD system, computer aided dispatch. So it'll give you all the details of the call that you're responding to. You can also message back and forth with that application.
That wasn't utilized.
It was turned off.
It was turned off. BMC, body worn camera.
BWC, yes.
That was also not activated.
Never activated.
Any communication devices were all not utilized to convey what was happening.
Correct.
How many times the respondent came to contact with the claimant prior to that night?
Prior to that incident, they had never encountered each other, but 2 times that night, the first time at the Dollar General and then the second time at the hospital when he had to get recalled back out there to deal with her. So 2 times that night.
Anything else from the board? Okay, at this time, does the subject officer and/or their counsel wish to make public comment? If so, you will each be given 5 minutes to speak, and the time limits will be strictly enforced. So please ensure that you complete your comments within the allotted time. While commenting, keep in mind that the board will only consider the facts as presented by the division today and will not consider any additional facts or defenses at this time. The sole questions before the board today is the following. If the facts offered by the division today are in fact proven at a later hearing, do those facts demonstrate a high probability that serious misconduct as defined in Penal Code Section 13510.8 and Commission Regulation 1205 occurred? So is there anyone from, before we get to the public, let me find out if either the attorney or the officer would like to speak. Please, come on up. And would you identify yourself for the record?
My name is Robert Sasek. I'm the officer in question.
Okay,
Good afternoon or
good afternoon.
good morning since it's almost afternoon. So I'd like to take full responsibility for what happened. It was a mistake. I did it with no malice intent. And I've learned from it. I spent my entire life my entire adult life in service. From the Army to being an officer, it's what I love to do, and I don't think that one mistake should make me not be able to do that anymore.
Tell us what the mistake you made was.
The mistake that I made was lack of communication. I believe that I interpreted what I determined to be a potential Fourth Amendment violation over the 14th Amendment. I did not intend to leave her in harm, but I also didn't know where to draw the line of what, if she wants out and it's not a detention, I can't unlawfully detain her.
And why was that a mistake?
Because it led to her being placed in a worse position than she was in, and she suffered injuries.
Does Oroville Police Department have a motto?
Not that I know of.
Okay. When I think, or when you think about the motto of law enforcement or military, what do you think of it being?
Protecting people that can't protect themselves.
Okay. Was she someone who could protect herself?
Knowing what I know now, no, I don't believe she was.
You say knowing what you know now. Do you know more about her now than you knew that night?
I do know more about her now.
Okay. What did you learn subsequent to this event that lets you believe that you know more about her now?
I learned about her past history. I'm a wrestling coach, and a lot of my parents are parents who had substance abuse issues, and I've had some parents tell me that she has a lifelong history of substance abuse. She's been arrested multiple times for that, and I understand that it's a sickness, and you know, I wasn't aware at the time that she had such a prolonged use of it.
About how old was she?
I would say she was, I'm guessing, in her 50s.
Okay, so this is what I know about her. I gathered she was around in her 50s. She's barefoot. She's using meth or has some mental health issues. She has high blood pressure. She's either, erratic in her behavior, either screaming to get out of the car and screaming, MF and throwing rocks or not. She's all over the board. And when you dropped her off and at this desolate place in that condition, did you view that as protecting and serving?
No, but I also wasn't sure where she wanted to be. I know from between Neil Road and Estates Drive, which is where I believe that Sergeant
Uh-huh.
Hahn had mentioned, was nothing but transient camps. So when I made the decision to let her out of the vehicle as she requested, I did not want to leave her on Highway 99 because I didn't think that that would be a smart decision. But if I let her make her own decisions from a safe place, that's her decision.
Okay. Questions?
Yes.
Please. Dr. Gova.
You said that there's a lot of transient camps. Was there transient camps in that area in which you dropped her off?
Not particularly, but again, I did not want to leave her on Highway 99. I would say from about a quarter of a mile, maybe a little bit more from Neil Road North. There starts to be transient camps. There's foliage and grass and like a golf course on the side of the road. And that entire strip all the way into Chico had transient camps in it. I believe there's a wildlife preserve where people go fishing off to the eastern side of the road, where I know there was several camps also.
So knowing that it was that close in proximity, why didn't you drive her to the transient camps and drop her off versus dropping her off in a desolate, unlit area?
Because the transient camps aren't necessarily accessible. They're behind roads. So it would be a quarter of a mile or a half a mile extra walk for her to get to a place where I would have been able to drop her off, but I didn't feel safe or smart leaving her on Highway 99.
How many times in the past have you left individuals that were not detained in isolated areas? Is that a common practice?
None, ma'am. This was a very rare occurrence.
Is there do Oroville have any policies or anything in place that give you direction on what to do with such a person?
No. I referred to my supervisor. I let Sergeant Khan know that she freaked out and he said, okay. That was my interpretation of what I should do.
Is there a policy about turning your camera on and off?
It was common practice of using it in an incident, and then if it wasn't necessary, you could turn it off.
It's your policy?
That was our policy, yes, or at least our common practice.
Okay, so there's a difference. So is it policy or common practice?
I'm not sure. I'll give you that answer. I'm not entirely sure. I know that I believe that it's not required because I know that I had an incident when I was just off training where our lieutenant yelled at me about it should be a shall section, or it should be a shall section.
Okay. Next question.
Yes, ma'am.
Do you have a daughter?
No, ma'am.
Do you have a mother?
Yes, ma'am.
Would you want your mother dropped off in a random isolated place, not lit, with no shoes on, under the influence of drugs or mental impairment?
No, ma'am, I would not,
So why would you do someone else's mother that way?
because she said that she wanted out and I didn't feel I had the right to detain her.
That's all. Yes, Dr.
You think she knew where she was when she asked to get out? Out of the vehicle?
Or if she knew exactly.
You should have had questions about whether she was making a good judgment about getting out of that location.
Knowing what I know now, yes, I should have asked more questions, but when she got out of the car erratic and trying to start a confrontation, I didn't feel the need to ask any more questions.
Any point later in the night, did it occur to you that you should alert somebody to her location, given that?
I let Sergeant Khan know right when I got back into town, sir.
I have another question.
Yes, ma'am.
Knowing what you know now, I'm struggling with that statement because I don't know what you know now that made a difference in how you acted then. So I'm really, can you walk me through that? I'm a little confused.
Again, with the 14th Amendment, making sure that we leave people in a safer position. I wasn't as aware of how, I'm trying to think of how to say this, that it would give me more authority.
Did you not know the amendments then?
No, ma'am, I knew the amendments, but I wasn't as sure on the 14th Amendment on its requirements to make sure you leave somebody in better care after contact.
How long you been an officer?
I was an officer at 14 months at the time, ma'am.
14 months. And you were in the military prior to that?
Yes, ma'am.
Thank you.
Yeah, I'll get, just to follow up on Dr. Glazer, and I'm not sure he's done. You said that she, remind me of your question again, Dr. Glazer, because it was a takeoff on that.
Well, I first asked if it was likely that she knew where she was when she asked to get out of the vehicle. And then I asked if Officer Sasek had contacted anyone, or I asked if he thought to contact anyone.
Right, and what you said, I believe you told Sergeant Khan that she freaked out.
Yes, ma'am.
Did you say anything else besides she freaked out?
I told him she freaked out and demanded to get out of my vehicle, and he didn't ask any more questions.
Okay, and you're aware that he didn't remember you saying he freaked out?
I'm aware of that.
Okay. And did you say, hey, man, she was barefoot, anything else besides the word she freaked out and demanded?
Oh, ma'am, I did not.
Okay, and he didn't ask you any more follow-up questions on that?
Oh,
And
ma'am.
that was about the same time there was a fire and a few other things going on?
Yes, ma'am.
Okay. Do you think he heard you when you said he freaked out?
Yes, because he acknowledged me. He said, okay.
Okay. All right, thank you.
Yes, ma'am.
Yeah, did you have some questions?
Was there
Mr.
first-
Johnson? Okay,
Oh.
please.
Yes.
But 1 second, were you done? Okay, yes, Mr. Johnson.
I think you was asked earlier, the model of being a police. And what was your response?
to protect those who can't take care of themselves, sir.
I think the people expect the model to be serve and protect, right? She was in need of service when you first in contacted her, right? And she was eventually, of course, taken to the hospital, created a commotion. And of course, you responded, and the service you provided was to drop her off on a dark, dirt, 2 mile and a half from services by herself. And then she was struck by a vehicle. Do you believe you provided her some service?
Her service that she needed, sir, was she was trespassing, so she was arrested for it. And then afterwards, I believe I was trying to provide her a service because she said she wanted to go home. And then again, I go to the point where she wanted out and I didn't feel I had the right to detain her. So I let her off in where I deemed a safe area as quick as possible without violating her rights.
Struggling with that. She thought she was going home, but she said she wanted to get out.
Yes.
And you felt it was okay just to put her out on a dark, dirt, lonely road, about 1.5 miles from services.
So this is the way I look at it, sir. I was always explained from the beginning of the academy to any time in law enforcement, when it's a consensual encounter, a person has the right to walk away. It doesn't matter if we're mid-conversation, if they start the conversation, if I start the conversation. She said she wanted out. It's my legal obligation to allow her her freedom. That's how I interpret it.
That, yes.
All right, I have a couple of questions. So you said earlier that one action should not define the sum of your career. Is that correct?
Yes, sir.
All right. This woman suffered sepsis, loss of toes. She now has to utilize a colostomy bag and has lost a length of her small intestine. Where do you draw the line? Did she have to die for you to have that one action define your career?
No.
Could this situation have been avoided by taking her to the hospital and getting her the medical attention?
Yes, potentially, but only in the meaning of if I would have gone in and got a medical clearance and then had continued the arrest versus me arresting her, giving her her citation and saying, here's the front door, you should go seek medical attention, which was what I did. The only thing I didn't do was walk her into the hospital.
And again, the best evidence for what transpired on Neal Road would have been preserved by a body-worn camera. Is that true?
Yes.
Okay. And do you know currently what the policy is for utilization of a body-worn camera?
I don't know if they've altered it or not.
What was it at the time?
It was a may use.
Thank you.
Johnson, once again. For clarity, the internal affairs interview, I believe you were asked a question about why the body-worn camera wasn't turned on.
Yes, sir.
What was that reason?
So the body-worn camera that we had at the time, so let me ask the question to clarify. Do you mean when I let her out of the vehicle, or do you mean throughout the entirety?
Throughout the entire incident.
It wasn't common practice. When I initially contacted her, she was causing issues, so my body camera was on. And then when she calmed down and the rest continued, we deactivated.
Well, the policy sits around that if there's no confrontation, no need to turn it on.
It's our common practice.
Is it policy or common practice?
I don't believe it's a policy violation.
Thank you. So she says in her interview that she didn't ask to get out there. That she didn't request to be let out of the car on Neil Road. And she tried to ask you about it, and you answered her very sternly about, don't ask me, basically.
So how she said I talked to her, that's not how I talk to people, ma'am. She requested to get out and I let her out. And when I let her out, I tried to say what's going on and she stormed off.
Uh, so when you initially took her to the jail, they said has high blood pressure. We can't admit her, take her to the hospital, right?
Yes, ma'am.
Are you aware that high blood pressure can lead to stroke or heart attack?
Yes, ma'am.
She also says in her interview that she was dehydrated. Did she ever ask you for water, or did you offer her water at all?
No, ma'am, she did not ask me for water and I didn't have water in my vehicle at the time to offer her.
And what was the temperature that day?
It was hot. It would have easily been in the hundreds throughout the day. It was the nighttime, so it was probably dropping down to 90s.
Are you aware that dehydration can lead to delirium and disorientation?
Yes, ma'am. She wasn't exhibiting any signs of dehydration when I contacted her.
Okay, but sometimes disorientation can look like somebody's on drugs, for example. Did you know that that's a symptom of dehydration?
Yes, ma'am.
Johnson? Oh, I'm sorry.
Trina,
Nothing further.
okay.
Yeah, Johnson.
Mr. Johnson.
Yes. The other officer had mentioned Mill Road. And you were on your way to taking her to Oroville, if I remember correctly. Was it Oroville, Chico? Chico.
Yes, sir, from Oroville to Chico.
Right, but he suggested, just drop her off over there. And it's my assumption that she didn't know where she was at and she questioned why you was taking her there. And then she, maybe out of fear, wanted to get out the car. Based on this whole experience for you, you had a situation like this again. What would you do what would you do differently?
If I could do the whole thing over again,
Yeah.
I would have got a jail clearance and I would have taken her back to jail. Had I not gotten a jail clearance and I had to contact her at the hospital, my body worn camera would have been on the entire time. When I restarted rims because it was acting up, which I was advised to do that in the past by Sergeant Khan, is when we have issues with rims, just go do a hard reset on your phone. I would have stopped and waited and let the whole system reboot up. I don't like to drive and be on my phone, even though we have an exemption. I still think it's unsafe. So I wouldn't have, stopped at a stoplight and tried to turn it on, and then the light turns green and I'm not going to play on my phone. So my body camera would have been on, my rims would have been on, and I would have been able to avoid this situation.
And in the direction of going to Chico, you probably wouldn't have dropped her off on some dirt road.
Had she requested to get out again, I probably would have stopped on the side of the road, contacted my supervisor, and figured out what to do next. Again, I was a young officer in the beginning of this, and I know that I made mistakes. And I don't know how to say it nicely. It sucks because this woman has experienced horrible things. And I'm sorry for that.
Anything else? Thank you, officer.
Yeah.
Is your attorney?
I don't have any counsel. It's just me, ma'am.
Okay, all right, fine, thank you. Would the board like to meet, or would you like to, would anyone like to raise a motion? What would? Oh, is there public, thank you. Is there public comment? Yes. Okay, there's someone on remotely with public comment? Yes, no? No. It doesn't appear that there is someone interested in making public comment remotely. Okay, so back to the board. Would anyone like to make a motion or would you like to meet privately? I'm sorry.
We'd like to go into closed session.
Okay. We will, let's see, we will now reconvene to regular session to take a vote on the board's recommendation in the manner of 2318309 Robert Sazek, who at the time of the events at issue in this case was employed with the Oroville Police Department. Are there any comments that the board has on this matter? Okay, before we get to a motion, I'm sorry, did you have a comment? No. Before we get to a motion, I want to point out that board member Regina Crawford left about an hour ago because she had an earlier flight. We still have a quorum here, so we're still going to go ahead with a motion. If there is such a motion, is there a motion to make a recommendation to the commission in this matter?
Yes. Move to decertify.
Is there a second?
A second.
And I will now take a roll call, vote on the board's recommendation. Mr. Knapp, please take a roll call vote.
Thank you, Madam Chair. Clavo,
Aye.
Clavo, aye. Dudley,
Aye.
Dudley, aye. Glacier.
Aye.
Glacier, aye. Johnson,
Aye.
Johnson, aye. Lara,
Aye.
Lara, aye. And Pena,
Aye.
Pena, aye. That's 6 yeses. Motion carries.
Thank you. Motion passes. Future board meeting dates. Upcoming board meetings will be October 8, 9, and all the board meetings will occur here in West Sacramento. Next February 4, 5, 2026, April 15, 16, 2026, July 15, 16, 2026. As this was the last item on the agenda, do any of the members of the board have any additional comments before we adjourn? Seeing none, I'll make a motion to adjourn for the record. Please clearly state your, seeing none, I'll make a motion to adjourn. For the record, please clearly state your name and your motion. What do I mean by that, Chandler? I'll just make a motion to adjourn and thank Chandler for doing a superb job. Do I have a second to adjourn? Okay, all in favor?
Aye.
We adjourned.